Okay, we need to clear up the biggest misconception surrounding Steam. The common claim online is that Steam isn't a monopoly, but I'm here to deliver the truth and take a deep look into the lawsuit that disputes this, because turns out Valve may be in big legal trouble. But first, how is Steam a monopoly? Aren't they naturally the best at what they do? Aren't they chosen by us, gamers? Well, this take is completely wrong, at least in the legal sense. A monopoly exists when a company holds sufficient market power that allows them to behave independently of competitors and consumers. It is generally accepted that market shares above 40% indicates a dominant position. Steam's share of the PC digital games distribution market is estimated at over 75%, which places it at nearly double the indication of dominance. Therefore, they are a significant monopoly in their relevant market. Now, this does not mean Valve has done anything unlawful. I will repeat, being a monopoly is not illegal, and in many cases, it's not even bad. That's right, there are many companies that are dominant because they deliver on superior products, better services, or stronger ecosystems. An example would be a company like Google and their dominance in the search engine market. The law does not punish success, nor does it care that consumers choose Steam voluntarily or prefer it to competitors. Competition law only cares when a dominant firm abuses that position by using anti-competitive practices to exclude rivals, distort the market, or ultimately harm consumers. So the real legal question of this video is not if Steam is a monopoly, it's does Steam abuse their position as a monopoly? Recently, Valve has been sued in the UK for £656 million, which equates to about $900 million. I've read the entire lawsuit. Before you call me a freak, I'm a paralegal, this is my job. I'm going to break down what the tribunal's judgment means as the case moves towards trial. We'll be looking at how both sides are positioning their arguments, whether Steam genuinely holds a dominant position in the PC gaming market, and what this means for us consumers. With that in mind, who are these claimants? The first is Vicky Shotbolt Class Representative Limited, a corporate vehicle used by this woman, Vicky Shotbolt. I wonder how she came up with that name. Vicky is a UK-based campaigner and expert on digital technology, children welfare, and digital rights. Her role is not about personal gain, but about forcing fairer competition and accountability in the PC gaming market. I'm not going to investigate this, so I'm just going to take her word on it. Supporting her is Milberg London LLP, who challenge anti-competitive conduct that harms consumers at scale. The lawsuit is brought as an opt-out collective action, which means all eligible 14 million UK Steam users are automatically included unless they've actively chosen not to. So for all of my UK viewers, and including myself, we are all making this claim. I understand that a lot of you are confused by this, especially as none of us have signed up for it. However, it is a method in place by the law to ensure fair accountability, as these claims usually affect individuals at a smaller scale. I'm not gonna lie, I might opt out. Let me know in the comments if you would do the same. The claimants allege that Valve has abused its dominant position by enforcing contractual rules that lock publishers and players into Steam's ecosystem. These include restrictions preventing games or DLC from being sold more cheaply on rival platforms, requirements that force game purchases through Steam, and a commission structure of up to 30%, all of which raises prices for consumers. With all of this set in place, we can now move on to the recent tribunal. It's important to note that the tribunal's judgment is strictly deciding whether there is a case against Valve. Within it, the tribunal focused on 3 specific issues. The first issue before the tribunal was whether Valve's commission charge on Steam amounts to an unfair price under competition law, imposing an unlawful cost on developers and publishers, which is ultimately passed on to consumers in the form of higher game prices. The issue arises because Valve currently charge developers and publishers a commission for selling games on Steam through a tiered structure, with the average commission rate sitting at around 27%. This is notably higher than the competing digital storefronts such as Microsoft Store and Epic Games Store, both of which charge a commission of around 12%. At first glance, one might expect developers to avoid Steam altogether in order to escape these higher fees. However, Steam's market position fundamentally alters this analysis. With an estimated 75% share of the PC game distribution market and access to over 147 million users, developers cannot realistically afford to exclude Steam as a sales channel. As a result, developers are effectively forced to accept the commission charge. Anticipating the reduction in revenue caused by this commission, developers are incentivized to increase the upfront price of their games to cover their costs, thereby shifting the economic burden onto consumers. This is why I disagree with takes like this.
Steam doesn't do anything to try and solidify this pseudo-monopoly.
Steam still has an incredible influence on all developers, and although nobody is forced to use them, when a huge amount of your sales is lost by not using Steam, it is incredibly problematic if a developer were to avoid them. Valve know they can get away with it because the developer realistically has no choice, with experts highlighting that were the market truly competitive, the commission rate would be around 17%. Interestingly, Valve did not deny that its commission rate is higher than the industry average. Instead, it focused on challenging whether its effective commission could be accurately established at all. Central to this defense was the role of Steam keys. Valve argued that because Steam keys are provided to developers free of charge and could be sold or distributed through third-party channels at a 0% commission, it is impossible to determine Steam's actual commission rate in practice. According to Valve, this unknown volume of zero commission sales distorts any attempt to calculate whether its pricing is unfair. Valve reinforced this argument by stating that it has no visibility over either the price or the volume of Steam keys sold. This problem is compounded by the fact that Steam keys are frequently sold outside the UK in jurisdictions where collecting reliable data is even more difficult. As a result, Valve's position was not that its commission was low, but rather that its true level was unknowable. Without an accurate figure, Valve argued that it could not be shown that the commission amounted to an unfair price. The claimant responded by relying on the broad axe principle. This principle allows courts and tribunals to estimate damages using sound imagination, where precise calculations are impossible. The rebuttal directly undermines Valve's defense. Even if the exact impact of Steam keys could not be quantified, this did not prevent the court from forming a reasonable estimate based on available data. The claimant also argued that if the relevant competitive benchmark were a 10% commission rate and Valve's effective commission could reasonably be estimated at between 20 and 25%, then the tribunal could confidently conclude that the charge was excessive, even with the uncertainty of Steam keys. So the claimants kind of offered the tribunal two routes to liability. Either the broad axe principle renders the uncertainty surrounding Steam keys irrelevant, or the tribunal could account for the Steam keys but still find their impact is insufficient to bring Valve's commission within competitive bounds. The tribunal concluded that Steam keys may distort the calculation of Valve's commission, but do not prevent it from being assessed or the broad axe principle applying. Accordingly, the issue should be addressed at trial. Okay, to me the claimant has a realistic but uphill chance of establishing excessiveness. If expert evidence convincingly places Valve's effective commission above a credible competitive benchmark, liability is plausible. However, the tribunal is likely to be cautious, and any finding of abuse would probably be narrowly framed, potentially limited to only certain periods or practices. This issue seems finely balanced, but Valve's unknowability defense is unlikely to succeed outright. The second issue concerns Steam's platform parity obligations, also known as PPOs. The claim alleged that Steam partners were prevented from selling games and DLC on other platforms at lower prices, earlier release dates, or in differentiated forms. These obligations were imposed through most favored nation clauses in the Steam distribution agreement, which prohibit developers from offering better terms elsewhere. PPOs restrict competition. Without them, rival platforms could compete more aggressively on price, which would place downward pressure on both game prices and Valve's commission. The existence of PPOs therefore prevents consumers from benefiting from lower prices due to their anti-competitive nature. A lot of this claim was based on economic theory, and Valve honed on this. They argued that economic theory alone is insufficient to establish a breach of competition law. It relied on case law where the CMA failed to demonstrate that MFN clauses had actual anti-competitive effects. Valve further submitted that it was not enough to show that PPOs existed or were compiled with. The applicant countered that direct evidence of the counterfactual market was unlikely to exist where a dominant undertaking had imposed PPOs throughout the relevant period. In such circumstances, reliance on economic theory is not only appropriate but unavoidable. That argument was a bit of a technical one, so let me break it down a bit. They basically argue that these PPOs have been used the entire time during the relevant period. There hasn't been a time without them, so you cannot analyse their effect to the market as they've always influenced the market. Therefore, they had to rely on theory. But the claimant also didn't rely on theory alone. It had analysed pricing data from 37 games and found empirical evidence. Variations in pricing patterns were said to reflect differences in how actively PPOs were enforced, thereby supporting rather than undermining the applicant's case. The tribunal rejected Valve's characterization of the applicant's case as relying solely on abstract economic theory. Instead, the claim combined theory with preliminary empirical evidence. While the claimant will still face a substantial challenge in demonstrating that PPOs materially affected prices or market structure, The tribunal accepted that wide MFN clauses imposed by a dominant undertaking are inherently capable of restricting competition. This is the claimant's strongest issue. If the evidence on price withstands scrutiny and the court accepts that Valve's PPOs reduce incentives for rival platforms to compete, a finding of abuse is more likely than not. Even if price effects are modest, the combination of dominance, wide MFNs, and orthodox economic theory places Valve in a very vulnerable position. And I honestly believe PPOs and MFNs are very anti-competitive. It essentially forces developers to make less money outside of Steam and forces them to sell on their terms. I have seen some argue that any storefront can just copy this. In theory they can, but this isn't the illegal point. Valve doing it in a position of dominance, that is where the problem arises. In other words, it is anti-competitive tactics used by Valve. The final issue concerned the identification of the proposed class. Valve argued that the class definition was unworkable, particularly because it introduced a large number of minors. Many minors use accounts to link to a parent or guardian's payment method and are unlikely to retain financial records. Valve further contended that Steam accounts themselves contain limited personal information, making it difficult to link transactions to identifiable individuals. They've put forward this argument to try and lower the amount of people who can make a claim. The applicant argued that these concerns were premature. Proof of class membership is not required at the opt-out stage and is more appropriately addressed at the distribution phase. The tribunal rejected Valve's objections. Proof of class membership and entitlement to damages is a matter of evidence, not certification. If the applicant were successful at trial, class members who could demonstrate qualifying purchases would be entitled to damages, while those who could not would simply be excluded. The tribunal therefore granted the collective proceedings order on an opt-out basis. So what does this all mean for the future of Steam? A finding of abuse would certainly force Valve to change how it contracts with developers. Restrictions such as PPOs or rigid pricing rules would become legally risky. That would immediately give developers greater commercial freedom, with the ability to now price differently across platforms, experiment with staggered releases, or offer incentives on rival storefronts. Over time, this would weaken Steam's role as an unavoidable gatekeeper. For consumers, the most immediate effect would likely be price differentiation. If Steam can no longer prevent cheaper sales elsewhere, rival platforms would have real incentives to undercut Steam on price, bundles, and timing. Even if Steam remains the preferred platform for many users, its prices would be constrained by credible alternatives. It's why currently nothing can compete with the Steam sale, as anything cheaper elsewhere has to be matched on Steam. Competitive pricing will only lead to cheaper prices for us consumers. Beyond price, consumers would also benefit from increased innovation in storefronts. At present, rival platforms struggle to invest aggressively because PPOs flatten competition. If those restraints fall away, platforms will need to compete on discovery tools, refunds, community features, mod support, and other areas where Steam is strong. This may lead to others like Epic Store becoming as good as Steam. Okay, that will probably never happen, but in theory, it can. Look, we all love Steam, and it was even difficult to portray them as the bad guys in this video. But they do have some serious work to do to prove they have not abused their position as a monopoly. What I will say is that Steam are one of the best monopolies around and provide a clear example on how one should operate. For now though, Steam is innocent until proven guilty, so they remain as a legal monopoly. That brings me to the end of the video. A like and a comment would be very much appreciated. I hope this video brought some better insight into the whole Steam monopoly situation. I know loads of videos float around claiming that Steam isn't a monopoly or they're too good or who cares because, we love Steam. But the law is the law, and I'm afraid if they have abused their position, then it will not look as good for Steam when it comes to the trial. As this will be going to trial, subscribe so you don't miss out on that future video. Hope you enjoyed. Thanks.